Good evening, everyone. We, the team of Legal Trendsetter, proudly present webinar on topic learning the art of drafting legal pleading and commercial contract by Sumit sir. Sumit sir is an advocate, is a practicing lawyer at High Court of Delhi. He got enrolled with the Bar Council of the Delhi with year 2002. He is an expert counsel of the Delhi commercial and constitutional cases. His filing PIL had resulted in the establishment of the 18 court and 22 commercial court in Delhi. He is frequently interested on the legal expert on the various news channels such as India Today, Ask India TV, and many more. He is also invited as a speaker on a various topic law in a various conferences. He has been he has been he has been commercial mediation by the Indian Institute of Corporate Affairs. He was awarded the National Law Day of India for his audition and former Chief Justice of India for audition and West former Chief Justice of India for his audition and a vast experience which played a vital role in the development and the recognition of the international mediation. Now I would like to invite Sir to continue this webinar.
Thank you, Sudhanshu. And first of all, before I begin, I would like to thank the legal trendsetters and Sudhanshu Tripathi for giving me this opportunity to so many students. I'm told there are more than 2,200 students who have enrolled for this. And I hope by the end of this, everyone will have a fair idea on how to do legal. And of course, drafting of legal contracts. So let me begin with first telling you and let us understand what are pleadings. Next. So friends, pleadings have been defined under Order 6, Rule 1. Now pleading includes two things. One is the plaint, other is the written statement. But at the same time, there are questions also which are filed. Though Order 6, Rule 1 doesn't define it, but as a matter of process, it has become part of the pleadings only if they allow the same. So now, when we file a case, and this is all important basics to understand drafting. So whenever you draft, there will be, or whenever a case is filed, there will be title to the parties that are filing the case. For example, in the suit, it's going to be a plaintiff on one side. Can we have the next slide, please? There will be plaintiff on one side and defendant on the other. In case of a petition, a petitioner on one side and the respondent on the other. And lastly, the complainant on one side and the other. Now, when you have the title of the parties very clear, another important thing that you need to understand is the court procedure before you start understanding drafting. Now, what is the court procedure? Let us take, for example, a suit. I'm getting some messages that there is an echo problem. Sudhanshu, can you do something about it? Right. So when we talk about the court procedure, what are the court procedure or what happens when we file a case in the court? Sudhanshu, there is still some echo problem. I am receiving some messages. Can you please do something about it? So when we file a case in a suit, we first and foremost, we file a plaint. When we file a plaint, the other person, the opposite side is summoned. In this case, will be a defendant. The defendant will then file his written statement to my plaint. And if the plaintiff so requires, with the permission of the court, he may choose to file the replication. Once the replication is filed, we say the pleadings are complete. Then the case goes to the stage of affidavit of admission and denial. Chapter 7 talks about this. Now, what is this? Now, to ease the process in the court feels and would recommend that both the parties may submit an affidavit and on oath can tell whether the documents of the other party, if there is anything which is admitted in those documents or those documents are denied, so that when we actually come to the stage of evidence, at least we have crossed a certain process and made it faster, the trial faster, because already the documents admitted may not have to be proven later. So the focus remains only on the documents denied. That is why this process or this stage is an important stage, though it's a procedural stage. After this, the case comes up for framing of the issues. Now, this is a stage where the judge will frame the issues. And while framing the issues, and what are issues? Issues is when one fact or a averment is said by one party and denied by the other, it becomes an issue. So the judge is now going to decide who has averred and who has denied it, and accordingly, while framing the issues, the judge is also going to make a note below each issue saying OPP or OPD. OPP means onus of proving on the plaintiff and onus of proof on the defendant. So each issue, the judge is not only going to say what issue is to be now proven in evidence, he is also going to mention who is going to prove which issue. Next comes the stage of plaintiff's evidence. Now issues are framed. So it begins with the plaintiff's opportunity to lead the evidence. The defendant gets an opportunity to cross-examine. And once all the witnesses of the plaintiff have been examined and cross-examined, the plaintiff's evidence or plaintiff's witness comes to a close and the defendant's evidence begins. In the defendant's evidence, again, the defendant will file his evidence by way of an affidavit and it will be cross-examined by the plaintiff's counsel. Once the evidence is complete, the arguments begin and finally the judgment is passed. So having understood this process, the procedure in brief, what happens in the court, let us now go to drafting of the plaint for which all of you are here. Next, please. I will begin talking about drafting of the plaint by giving you two very interesting quotes which talk about how to do a draft, or more particularly, they talk about what is the value of the first draft. So next, please. The first draft, there's a quote by Shannon Hale who says, "I'm writing a first draft and reminding myself that I'm simply shoveling sand into a box so that later I can build castles." There's another quote by Ernest Hemingway. Next, please. Ernest Hemingway says, "The first draft of anything is garbage." And friends, trust me on this. First draft, a lot of people have this tendency to just make the first draft and give it or use it or file it in the court. Please avoid doing that. When you make a first draft, you are only collecting your thoughts. You must give it a second reading, a third reading. In fact, I'll tell you, when I was working with my senior during the initial stages of my career, I would see my seniors drafting and I ask him, "Sir, how do I improve my drafting?" And he would say, "Sumit, there is only one way to improve your drafting, and that is by reading, rereading, and rereading your own draft." Trust me, That is the only way I have learned it, because every time you reread your draft, you will realize that there is some improvement to be made, and you will automatically improve it. And next time onwards, with those improvements and rereadings, your future draftings are going to become better and better. But even with all this, over the period of years and experience, I have figured out that basically there are 5 stages of a legal draft. And if you follow those 5 stages, you will be able to draft anything under the sun. So what are those 5 stages? Next, the 5 stages which I have made out of my personal experience, and I've divided this as follows. Stage 1 is paper sorting. Stage 2 is a client meeting. Stage 3 is legal research. Stage 4 is rough draft. And stage 5 is final draft. I'll tell you how each draft in detail, each stage in detail, as to what you should do. So in stage 1, what you need to do is, initially, this is the absolute first stage, when the client comes to you and he starts talking about his case. He gives you an entire background. This is the stage where you draw a sketch in your mind. When you've drawn a sketch in your mind, don't totally depend your drafting on this sketch. It is just a rough sketch. So along with, while making this, hearing the background of his case, he will also, on your asking, he will leave a bundle of papers with you. Once he leaves, once he goes away, spend time on those papers. They are the ones who will tell you the actual story. So how do you read those documents? First and foremost, put a date of a document on the top right corner of each document. Generally, I advise it to write it with pencil so that you can delete it later before filing. Once you've written the dates on each document, sort those documents date-wise. And when I say study each document carefully, what you need to do is study the date of that document. Now, this is very interesting. It may sound easy, but there are instances where there will be a date written on that document, and towards the end you find that it has been signed on another date. So it's very carefully that you need to study each document just to find the right date of that document. So while studying, what you need to do is make a table, which you can see here. In the first column, you write the date, you write the event, and then the source of that document. So that will be the title of that document, obviously. Say a letter written by Mr. So-and-so, the date on which it was written, and what does it talk about in brief. You also need to mention here those dates which are mentioned in that document. So when you do that, the only thing that will change is the source of the document, and where you're going to say that it is mentioned in document so-and-so. So with these document speaking facts, you're very sure as to what the true story of your client is. This is the time when you call the client for a meeting. Next, and we come to stage 2. Next, please. In the next stage, when you call the client for a meeting, you ask the client for his story with the dates. Now, in this case, he will give you an approximate dates. Now, make sure that you know all your facts before you open your mouth. And I'll give you a nice example to this after this slide. It's very important to hear him carefully. But now that you've read his documents and you're sure of the documents don't lie. So when he talks about a date which does not match with your list of dates and events, confront him, show him those documents, and ask him, Madam, the documents that you're showing are not matching with what you're telling me right now. And invariably, you will find the client will tell you that, sorry, sir, I was wrong, I had forgotten, the actual date of this event was so and so. So now you have some additional facts coming to you. So you increase the table where you will add one in the source column, one more category saying that this information is received by the client. So now you are very sure what are these facts with the documents, with mentioning in the documents, and with what the client have told you. So now in the court, you can easily prove the ones which are in the document and which have the documents with you. And of course, the client's words are going to be proved by way of a cross-examination in evidence. So we'll come to that later. Now we go to the next stage, which is stage 3. Yes, like I said, I'll give you an example after the slide, and that was to know all the facts before you open the mouth. Why is it important? So here, if I offered you $100,000 to jump from a plane without a parachute, would you do it? And I bet you would have said no. But what if I told you that the plane was on the ground? Moral of the story, know all your facts before you open your mouth. That is why when you talk to the client, when you listen to him, even before confronting him with the documents, listen to him carefully. So now coming to stage 3, which is the legal research. Next. When you start doing your legal research, read the relevant judgments and precedents. Nowadays, you have a lot of online softwares to support and help you find the relevant judgments. When you found those judgments on which are so-called relevant to your facts, ensure that your facts are supported by those judgments. It's very important because once you have the judgments in hand, you have the facts which are similar to the ones of your case and which have been mentioned in our precedents, then you already have a strong case when you file it, even at that stage. Read the relevant provisions of law. Supposing you're filing a writ petition under Article 226, you must read Article 226 and note down the ingredients of the law. Even for a simple case like Section 138, law may be very clear. A lot of us feel that, oh, Section 138 is such a very simple provision of law. But please read it, and trust me, every time you reread the provision, every time before drafting the case, you will realize, yes, there is something more to that provision of law. And noting down the ingredients of law is very important. I'll give you that example by way of Section 138 itself. So let us read Section 138 here. Next. Now, Section 138 of the Negotiable Instruments Act says, where any check drawn by a person on account maintained by him with a banker for payment of any amount of money to another person from out of that account for the discharge in whole or in part of any debt or other liability is returned by the bank unpaid, either because of the amount of money standing to the credit of that account is insufficient to honor the check, or that it exceeds the amount arranged to be paid from that account by an agreement made with that bank, such person shall be deemed to have committed the offense. So now if I have to take out the ingredients, and I have underlined it here, you need to understand the ingredients here are: 1, that check should be drawn by a person on an account maintained by him. Of that amount to another person. 3, it should be for the discharge of some debt or liability, whether in whole or in part, and it should have been returned by the bank unpaid, either because it was insufficient or because it exceeds the amount arranged. So when you're drafting a complaint under Section 138, for instance, you will make sure that all these ingredients which I've read out have been put into it. Next. Now you can see these 4 ingredients which I just spoke about. Once you've written down and segregated these ingredients in your notes, while making your draft, ensure that you made a mention of the facts of the case to be fulfilling these ingredients of law. This is very, very important. It may look simple, but no, you need to pay attention and ensure that this is done. Once you've done this part, when you've made your draft with all your ingredients of law and cases supported by case laws, your facts, then you prepare a rough draft, which is the stage 4. Next. In the stage 4, now you will have the final list of events in hand, which includes information from the documents, from inside the documents, and from the client. And you have the names of the parties. You've titled them properly, like I initially told you how. Then you start with drafting the paras, introducing the plaintiff and the defendant. Put the final list of events in a story mode. So now you have the title of the parties, then you have the provision of law. You initially begin with introducing the plaintiff and the defendant, that the plaintiff is so and so, doing so and so business. The defendant was in so and so business or a trader, and he approached the plaintiff for a certain purchase of some goods for which he gave him some money, which needs to be recovered in this case. And then you have that entire list of events now that you had prepared by seeing the documents and with talking to the client. You put them in a story mode. And then you add the mandatory paras as per the facts of your case. Now, what are mandatory paras? Next. Mandatory paras have been mentioned in Order 7 of the Code of Civil Procedure. Now, what are those? 1. The cause of action, the territorial jurisdiction, the pecuniary jurisdiction, limitation, value of the suit and court fees affixed, and the prayer. Then you prepare the final draft. Keep the following in front of you: the file to refer to the documents given to you by the client, the list of events which you've prepared, and that rough draft. So 3 things, keep it in front of you, and then give a final reading to your rough draft. Check for a clear storyline, grammatical errors, etc. And wherever there is a doubt, you can refer back to your list of dates and your documents. Ensure that there is no missing link. Ensure that all the ingredients of law have been fulfilled. And then make the supporting affidavit, which has been defined under Order 6, Rule 15, Sub-Rule 4. Now it is said that every pleading must be supported by a supporting affidavit. But what should be the contents of that supporting affidavit? Next. The content should include that the person giving the affidavit or signing this affidavit, that is your client, the plaintiff in this case, how is he competent to depose this affidavit? And once you've told him, yes, he is the plaintiff, he is aware of the facts, he is competent to depose this affidavit, then you must say that the accompanying pleading has been drafted under his instructions and it has been read out to him in his vernacular language and has been understood by him. Of course, it's an affidavit, so you'll be writing this in first party, where you would say that, yes, it has been read out to me in my vernacular language and understood by me. Sorry, we need to come to the supporting affidavit slide. The next one. Yes. So it has been read out to me and understood by me, and no part of that accompanying pleading is false and nothing has been concealed therefrom. Of course, after this, the attestation has to be done by an oath commissioner. Now, I have specifically written notary public here just to clarify that a lot of people get the attestation done by a notary public. There is a different purpose for which a notary public has been authorized and for which the oath commissioner has been authorized. Any document which is going to the court has to be attested by an oath commissioner and not by the notary public. Keep that in mind. It's a very simple thing to remember. So basic points I will come to. If we have the next slide, please. The basic points in a drafting, in a legal drafting, that you need to keep in mind is that you keep the language simple. And I would here give an example of Indira Gandhi's case. This is the case where for the first time ever in a court, the sitting Prime Minister was called as a witness to the case. Now, Prime Minister, of course, has the option and the protection under the Constitution to have refused. However, in this case, the then sitting Prime Minister, Mrs. Indira Gandhi, decided to come to the court. And in the court, that affidavit was shown to her. And on that affidavit, she was cross-examined by Mr. Shanti Bhushan, advocate. And while cross-examining, he put to her certain questions, because of which Indira Gandhi ji decided to say or said that she has signed this affidavit, but she does not know the contents of it because these are legal languages and she doesn't know. She can't understand. So at that stage, Mr. Shanti Bhushan put that affidavit to her and said, "Madam, I'll read out this affidavit to you and please tell me which part of it is so legal that you can't understand." And like I said, a good drafting is of simple language. So there was nothing in that affidavit which the then sitting Prime Minister could say that, sorry, I could not understand. So this is actually a case where this had happened. This is a true story. And that is why it is said that you must keep your language simple in all draftings. A lot of people have tendency to use big heavy words, make it long and lengthy drafting. Please do not do that. Because if you do a long drafting, you will end up doing repetitions, and a good drafting is the one which does not have repetitions. Use the words as much as possible from the documents. Long sentences should be avoided. Pleadings should be very specific. There should be no ambiguity. And prayer should be very specific. Now, there's another case here which I can talk about. This actually happened in the court. During the initial stages of my career, there was one consumer matter I was doing where I was representing a company, and the company which manufactures refrigerators, the consumer said that his refrigerator is not working. The company had given me the instruction that I am open to settlement. So I requested the court that yes, the company has given me instructions that they are ready to settle this case by way of giving him a replacement or a refund. So the judge asked this consumer who was appearing in person. He said, "What is your prayer? What do you want?" And the consumer, innocent as he was, he said, "I want to teach this company a lesson." Now, the judge said, "That's okay, but what do you want?" And what the judge meant was, do you want a replacement or do you want a refund? Because that's a prayer you should have made in your complaint, but unfortunately he didn't. All he said was, "My lords, I only want to teach these people a lesson." So unfortunately, he did not get the relief what he was asking for because he was not specific in his prayer. And last but not the least, keep the choice of words. Be very selective about it, what words you use in a case, because each word can make a huge difference. Now, this is a case where Mr. Nani Palkiwala, advocate, was approached by some gas manufacturing companies, and they said that they are being charged tax on a certain reason that They have been, whenever these dealers come to purchase the gas, they leave the cylinders there and they do not take it up for long, despite our follow-up. So what they decided to do was that they said we will charge them a rental for that, so that they are not inclined to keep their cylinders in the premises of the manufacturer. Frankly, it was not for earning money, but since it was only to act as a deterrent that they take the cylinders back at the earliest possible. But since they were calling it a rent, it became a taxable income. And that went on for in crores of rupees. So they approached Nani Palkiwala ji and they said, "Sir, please guide us. What should we do?" And Mr. Nani Palkiwala only told them that change one word in your contract. Instead of calling it a rent for keeping the gas cylinders, simply call it gas keeping charges, a cylinder keeping charges, and it won't be taxable under law. So imagine, with one change of word, the companies were able to save crores of rupees. Having said this, I'll conclude my legal pleadings and now come to contract drafting. Next, please. Now, contract drafting is very interesting, and like I told you in the legal pleadings also, you should be very specific about whatever you want to say in your contract drafting. It's very important, and I'll show you how. Next, please. I'll show this by way of an example. Next. How to be specific. So if I was to give you an orange and ask you that if you were to give this orange to someone, how would you offer it? All of you, and most of you, in fact, I would say that, "Sir, here is the orange, please have it." But no. When a lawyer is drafting this in a contract, he will be as specific as this. Next. He will write in the contract that I hereby give and convey to you all my rights, interest, claims, and title to that said orange, along with all its rind, juice, pulp, and seeds, and all the advantages thereto, with full power to bite, cut, freeze, and otherwise eat the same, or in any manner give the same away to any person, with or without the pulp, juice, rind, or seed. So do you see now, with this being specific, how detailed that you've given him the total rights and authority over that orange rather than just offering it to him. The intention is made clear only when you are specific to the depth of it. And why is being specific important? This I will tell you by a Akbar Birbal story. Next, please. So in this story, and can we have the next slide as well? In this story, what had happened was that once a man sold his well to a farmer. Next day, when the farmer went to draw the water from that well, the man did not allow him to draw the water from it. And he said, "I've sold you the well, not the water. So you cannot draw the water from the well." This became an issue. This bad contract drafting. They did not mention that the water will come along with the well. So too bad. So they go to the court and the matter is referred to Birbal. And look what Birbal says. He solves it finally. Next slide, please. Next. Yeah. So Birbal said that since you have sold the well to this farmer and you claim that the water is yours, then you have no right to keep the water in that farmer's well. Either you pay the rent to the farmer to keep your water in his well, or you take it out of his well immediately. Simple solution, but definitely a bad contract drafting. That is why being specific is important. And I'll give you another example to this. This is the story of the Merchant of Venice. Next, please. It's a 16th century play by Shakespeare. What had happened in this, and I'm sure many of you would have read it also. In this story, what had happened was Antonio was short of money because all his wealth is invested in his fleet, which is currently at sea. So he goes to a Jewish moneylender named Shylock. Now, though Shylock hates Antonio, but he agrees to give him a short-term loan on a condition that the loan must be repaid in 3 months or he will extract a pound of flesh from Antonio. Now, Antonio agrees, confident that his ships will return in time. But Antonio's ships are wrecked and the date for the repayment to Shylock passes away. So Shylock now says, please give me my pound of flesh. That means his intention to kill Antonio was now very clear just because of a bad contract drafting. So they go to the court, and what the court decides is again very interesting. He's able to come out of it. Next slide, please. The decision is Shylock can have the pound of flesh as long as he doesn't draw blood. So see, bad contract drafting saved him here, but definitely keep in mind that your drafting should be very, very specific. So with this, let me come to some legal points, important legal points that should be there in a contract drafting. Next. So first and foremost, of course, when you're talking about contract drafting, you have to go with the facts of the case. You have to go with whatever your client wants and what the intentions are. Of course, the business and commercial terms are to be decided by the clients. You can only twist it to an extent to make it more favorable in favor of your client. But these clauses are legal clauses which should always be there and very clearly there in all your contract documents. First and foremost is the termination. Now, termination can be in three manners. One, it can be a termination by consent. Two, it can be termination on account of a breach of any terms of the contract. And third, it can also be a termination by a flux of time. Coming to termination by consent, in this you write, either of the parties may terminate this agreement without cause or by issuing a notice of not less than 1 month prior notice to the other party, and this agreement shall stand terminated immediately on the expiry of that said notice. So it's a notice at will. Nobody has to give any explanation why they want to terminate it, and they may terminate it by giving a 1 month prior notice. Again, like I said, these are to be discussed with your client, but you can always suggest these three termination clauses to your client. Second is termination on account of breach. Now, either party may terminate the agreement immediately upon written notice to the other party in the event that the other party fails to perform any material obligation under the agreement. So, in case of a breach of the agreement, the termination can be immediately terminated upon written notice. There you don't have to give 1 month notice. And last but not the least, termination by a flux of time, where you say that this agreement will automatically stand terminated by a flux of time at the end of the tenure of this agreement. So this overall clears out the termination clause in your contract. Next important legal clause that you must put in every agreement, and next slide please, is the notice. Now, in the notice clause, you must mention that any notice or other correspondence under or pursuant to this agreement may be issued by a party to the other, because it's both ways, and shall be deemed served if sent by hand delivery against acknowledgement, through registered post, courier, WhatsApp, or email, any of these modes, if sent to the following address, and then you may give the address of party 1 and party 2, similarly the email and WhatsApp numbers of both the parties. Next, another important clause, legal clause to be put in the contract, and we have the next slide, is mediation and arbitration. This is very important because nowadays, with the Commercial Courts Act, every case has to go to mediation, every commercial case. So you may as well in the agreement itself choose where you would like to go for mediation. So in this case, I have drafted, if any dispute arises between the parties hereto, in connection with this agreement, the parties hereto shall endeavour to settle such disputes amicably by referring the matter to the Delhi High Court Mediation and Conciliation Centre, also known as Samadhan, at New Delhi. And in case the parties fail to settle their disputes in mediation, either party shall be entitled to refer the disputes to arbitration. So once mediation is over, then they go to arbitration. Court is still far away. So that they will refer the disputes to arbitration under the aegis of the Delhi International Arbitration Centre of the Delhi High Court, Delhi, and the cost of the arbitration shall be mutually borne by the parties. So you've also specified it will go to arbitration before whom? It may be an individual arbitrator, it may be an institution like the Delhi International Arbitration Centre. Now, once you mention these two facts, you must mention where that arbitration will take place and what will be the law governing it. So I've said the venue of the arbitration shall be at New Delhi, and the same shall be governed by the provisions of the Indian Arbitration and Conciliation Act 1996, or any statutory modification as may be then in force. The arbitration shall be conducted in English. The order passed by the arbitrator shall be final and binding upon the parties, and the cost of arbitration shall be mutually borne by the parties unless anything contrary to this is passed in the order. So with this, your mediation and arbitration clause gets covered totally. The next important clause is the jurisdiction. So you roughly mentioned the jurisdiction of the arbitration, but you must mention that is that the only jurisdiction, or do you want to exclude all others? So the next slide, please. We talk about the jurisdiction, where we say that any and all questions of enforceability and interpretation which may arise under this agreement and applicable product addendum shall be determined and governed by and in accordance with the laws of the Republic of India. And if any dispute or differences arises under or pursuant to this agreement, such dispute shall be finally decided by the courts in New Delhi, and the parties submit to the exclusive jurisdiction of Delhi courts. That means if the other party using some cause of action tries to manage a jurisdiction elsewhere, you can get a stay on that and request for transfer of that case back to New Delhi just by this clause. Next important clause you must mention in your agreements is the force majeure clause. Next slide, please. Now, force majeure in today's time has become very important. So, you must mention that neither party shall be liable for delays in performance when caused by any of the following, which are beyond the actual control of the delayed party: acts of gods, acts of the public enemy, acts of civil or military authority, government priorities, strikes, or other labor disturbances, hurricanes, earthquakes, fires, floods, epidemics. Now we've added pandemics, embargoes, wars, riots. Now, do you see that pandemics has now started coming up in every force majeure clause of the contracts? Unfortunately, people were just restricting themselves to epidemics so far. And third, you must mention in the force majeure clause that in the event of any such delay, the date of the delivery or of performance shall be extended for a period equal to the effect of time lost by reason of the delay. This, your force majeure clause also gets covered. Another very important point, a legal point that you must mention in your contracts is the entirety of that agreement. Which agreement? Is there any addendum to those agreements? Is there some more agreements? You must clarify, no, this is the only agreement which is going to be relied upon. Next slide, please. In the entirety of the agreement, you mention that this agreement constitutes the entire and complete agreement between the parties regarding the subject matter hereof and supersedes all prior agreements, understandings, negotiations, proposals, and representations by the parties with respect to such subject matter. No change, modification, amendment, waiver, or discharge hereof shall be valid unless it is in writing and is executed by both parties. So now there is no ambiguity that the only thing what we call into agreement is this agreement, and it supersedes all other prior understandings in whatever manner they were written. Do you see how specific it has been? So keeping all these things in mind, I'll just briefly revise you what are those important legal clauses that should be mentioned in every contract document. Next slide, please. One is the termination, the notice, mediation and arbitration, jurisdiction, force majeure, and entirety of the agreement. So with this, I hope all of you are very clear. Next slide, please. I would conclude with this. So thank you very much, and I hope you all have benefited from today's discussion on legal drafting, and hope you will be able to make your drafting with the help of whatever I have discussed with you today. Thank you. Sudhanshuji, you are on mute.
Thank you so much, sir, for addressing us and giving us informative lecture series.
Thank
Thank you so much, sir.
you. Thank you.
Thank you, sir.